Hello and welcome to our trustee workshop at Gaughan and Keneally. We call this the Trustee and Personal Representative Toolkit. We've got some practical considerations when you've been named in a loved one's estate plan. So if you've been named a trustee, a power of attorney, a healthcare power of attorney, those types of jobs, this is for you. The way we're going to go through this, first do some introductions and then kind of tell you what we're going to talk about today. Introducing the firm. This is actually me, the guy who's talking right now, Casey Keneally. You'll see it's K period, C period. It's actually just a cruel joke my parents played on me when I was younger. Everybody just calls me Casey. I am the Keneally half of the Gaughan and Keneally law firm. I am a licensed attorney in Kansas, Missouri, and various federal courts. Been practicing since about 2004. This is Chris Gaughan, other half of the Gaughan and Keneally firm. He's also a licensed attorney in Kansas, Missouri, various federal courts, been practicing since 2004 as well. Actually, Chris and I were old high school buddies. We grew up together and went to high school together some 25 plus years ago, and have been practicing lawyers since we got out of law school in 04. A couple other folks you might see around the firm if you come in or you call and you need to talk to somebody. This is Nikki Piscurik. She is a licensed attorney in Kansas, Missouri. She is an attorney that works with Chris and I. She handles a lot of what we would call the post-mortem work, or the work after a loved one passes away. So if there happens to be some probate that needs to be done, Nikki's the one that does it. If there's some trust administration that needs to be done, Nikki's the one that helps us with that. She's the expert on getting things done after a person passes away. Also, if you call the firm or if you register for a workshop, you get one of our emails, any of our marketing materials, probably put together by Jamie Smead. So if you're looking for when the next set of workshops are, or planning those types of things, or you get an email, almost always that's going to come from Jamie. She's been working with us for a number of years now. She does all of our marketing, and she basically handles a lot of that client outreach that you might get from our firm. Tracy Rocker, she's director of our client services. She does a wonderful job. She is usually the first point of contact with our firm when you've got a specific legal type question. So when you're calling in and you say, I need to worry about, how do I get my house into my trust, or how do I fund this asset, or how do I open a bank account, those kinds of things. Tracy's going to be the person doing those things, helping with forms, answering those questions. She is Chris and I's right-hand woman. She really does a wonderful job for us, keeping us on the right track. And we've also got Brianna. Brianna is the receptionist. She's working up front, so when you call the office, you're going to talk to Brianna first. She's going to direct the call to Chris, to myself, to Tracy, to Jamie, to whomever. Brianna also will be the person that you see the first time when you walk in the office. So when you walk in the office, kind of got the front of the office where our conference rooms and drink station, everything are. That's Brianna's domain. She is going to be able to get up there and chit chat with you, show you where to go, help you get directions to the firm, all those kinds of things. She'll be right up front there to help you. So we're very pleased to have Brianna with us as well. A few resources that are available to you as clients of our firm. Certainly you can always go to our website, midwestestateplan.com, right there on the screen. And if you look on that website kind of screenshot there in the middle, you'll see a bunch of those tabs: home, who we are, communities we serve, services, resources. I want to direct your attention to the resources tab right there in the middle. If you click on that resources tab, you're going to get to a list of reports written for our clients about various topics. So if you say, I want to know more about special needs trust, there's a report on that. I want to know more about veterans benefits, there are reports about that. I want to know about how to be a trustee or a power of attorney, or any of those various types of issues. If you click on that resources tab, you're going to get some great information written by attorneys for you, so that hopefully you're not going to Wikipedia or something else on the internet that may not be as good a source of information. Hopefully that resource tab presents you with some really good information. At this point, I want to say, kind of funny, but congratulations. Your loved ones have taken the time to think about you and set up an estate plan to make your life easier. Hopefully it's going to make things go much more smoothly for you in the coming years when that inevitable happens, when somebody becomes disabled or passes away. And that's really why we're here. We want to make sure that it's easier for families as they go forward with the uncertainties that come up in life. And so the way I want to kind of frame the conversation we're going to have today, or the presentation we're going to talk about here, is I want to ask you a question. And by the end of the presentation, I think you'll probably have a pretty good answer for this question. But the question I want to pose to you is, if you got a phone call right now, literally your cell phone rang as you are watching this presentation, and you learn that something happened to a loved one. They fell, they had a stroke, they went to the hospital. Do you know what to do immediately? And when I say immediately, I mean, do you know what to do? Do you know who to call, who's in charge, where the documents are? All of those kinds of things. And if you don't know the answer to that right this minute, and that's okay, that's one of the things we're going to talk about today to make sure that we actually get those things taken care of for you the right way. So we're going to hopefully be able to answer that question by the end. And these are some of the questions that I was kind of going through. You need to know who's in charge, who makes medical decisions, where documents are that might control these items, and what do you actually go do. A lot of people get that call and they freeze. They're not sure what to do. They're not sure who to call. Do they go to the file cabinet? Do they get some stuff out? Do they drive to the hospital? Hopefully we'll give you a plan of action here today. And the way we're going to do that kind of in 3 parts, we're going to talk about some terms and essential estate planning tools. I want to make sure everybody's on the same page as far as how these things work and what terminology we use. Part 2, I want to talk about situations that we might use these tools. So we'll talk about the tools that we have, and then when do I pull these out? And then we're going to talk about some practical considerations for everyone. That's not just the folks that already set up this plan that maybe you're been named as a trustee for, but maybe you need to do something for yourself and your family as well. And we run into a lot of that. We see maybe mom and dad get something done, and then the kids come in and say, gosh, I really need to get something done for my kids too. And that's okay. You're in the right place. We can go through some of that for you as well. And it says questions and answers on there. Of course, this is a recording, so it's going to be harder to do questions and answers. Usually in the live presentations, we've got those available to you. But the easiest way to get questions and answers on this stuff is jot down the questions as we go. After you get the questions answered, fire them away in an email or maybe give us a call, and we'd be happy to hop on the phone or answer a few questions via email if you've got some specifics that you need answered. So first, what are we going to talk about here? Terms. What is an estate? An estate is literally everything you own. That's what makes up your estate. When I say everything, what am I talking about? I'm talking about life insurance. Yes, that's included, the full face value of the policy. You got $500,000 when you die, that's $500,000 in your estate. Because when we're talking about distributing these assets, we're talking about what's going to happen after you pass. So it's going to be the full face value of that life insurance policy. We're not going to forget about personal property. Personal property, when I say that term, what I'm talking about is things you can carry into your house. That's the easiest way to kind of describe that. That's TVs and couches and artwork and silverware and china and jewelry and all those things that you have. You don't really have a title. You don't have a document that says, I own this, but you know that it's yours. That's your personal property. Okay. Things with a title we're going to do a little bit differently. Things with the title, I'm talking about land you have a deed for, or maybe a bank account. You've got a statement with some ownership records. We're gonna kind of make a distinction between the two of those categories. But personal property is the stuff you carry in your house. That's also included in your estate. Of course, your retirement plans. We're talking about 401ks, IRAs, Roth IRAs, SEPs, any kind of retirement plan that you might have is included in your estate. And so we've got all this stuff, right, that is in your estate. So what is estate planning? Well, it's kind of goes in 3 different categories, and our firm helps with all 3 of these. But we're going to focus today kind of on one of the 3 pieces of this pyramid. Number 1 down there at the bottom is accumulating wealth. Accumulating wealth is the stage where you are working, you're on upward trajectory, you're saving money. This is your working life, right? Maybe 25 to 65 or so whenever you retire. That's the accumulating wealth stage. We're accumulating, we're getting more, we're saving as we go. Then there's the preserving wealth there in the middle. Preserving wealth happens basically around the time of retirement. We say, okay, I'm retired now. I'm not going to make any more money necessarily, so I've got to make sure that my investments work for me. I've got to make sure I can survive on Social Security and my investments and other pensions that I might have, and I want to preserve my wealth. I want safety for my principal, safety for the money that I've saved during my life so that it lasts a long, long time. And then finally we get to that distributing wealth, the top of the pyramid there. Distributing wealth is the thing that we're going to focus on the most today. That is, after somebody passes away, how do we get their assets from one generation to the next? How does that work? What do we do? What's the process look like to get that done? So what are the challenges when we're talking about that distributing wealth stage, that top of the pyramid, if you will? There are a lot of different challenges that we go through. Number 1 is honoring a decedent's final wishes. We want to make sure that wealth gets transferred to whom we want, when we want, the way we want, and certainly at the lowest possible cost. That's always really, really important for us to be able to do that the right way. And so I want to make sure that when we talk about distributing wealth, we take all those things into consideration. So The next thing I want to do is go through some terms, or what I like to call the essential six. These terms, or these documents that we're going to talk about, are very, very important, and these are the 6 documents that nearly all of our clients have. There's a few exceptions here and there, but for the most part, these are the documents that you need when you're working with our firm and you want to have an estate plan set up. We're going to talk about a living trust, a will, durable powers of attorney for financial decisions, healthcare powers of attorney, which is a separate document, of course, a living will, sometimes you'll hear that called an advance directive, and a HIPAA release. We'll talk about all those 6 of those in a little bit of detail here to make sure we're all on the same page and these make sense. I think if you have an understanding of what these documents are, it's going to make a lot more sense as to what you have to do when you have one of these. So first is a living trust. Living trust, the number 1 document there, in its most basic, simple terms, it is a written set of instructions for what you want to have happen if you die or become disabled. And that's really important. I want to make sure that I stress the disabled part. A living trust helps in the case of a disability. A will does not. A will only takes effect at the time of death. A living trust helps you when you are disabled or incapacitated as well. Okay? This is the most sophisticated document that we use. It handles almost any contingency in the case of a death or an incapacity. So it's got a lot of things built into it. So if you say, gosh, I wasn't planning on this happening or that happening, the living trust is probably set up to handle most of those contingencies for you. It's got very logical steps that takes us all the way through the process. And the biggest question, or the number 1 question that we usually get at our office when we're talking about trusts and wills, are what is the difference between a will and a trust? What's the biggest difference? And the most simple answer for that, quite frankly, is the way that you hold title to your assets. Well, you hold title to your assets. That's the difference between a will and a trust. Okay, there's lots of differences. That's the big one, though. And that's the one I want to talk about for just a minute, because when you understand that concept, the rest of this starts to fall into place. And so how do most people hold assets, right? They hold them in their own individual name. So if you own a home and your name's John Smith, the home is owned by the individual John Smith, right? He's the person that owns the house. That's the person on the deed, which means it's really, really simple for us to transfer that house if John Smith wants to. We draw up a new deed. John Smith can sell the house. He can give it away. He can add people to the deed. He can do whatever he wants. It's his home. He's the one that's on the deed there. It makes it really simple for him to transfer, gift, move, sell, whatever he wants to do with that house, because he's the owner, okay? And when you're married, a lot of homes are owned jointly. Financial accounts are owned the same way, usually in your own individual name, or if you're married, sometimes they're held jointly. Unfortunately, when you hold property in your own individual name, this is going to necessitate probate. And what do I mean by it's going to necessitate probate? Well, what happens here? And this is the big one. When you're alive, it's really easy for me to slide that deed for your home across the table to you, and you can sign it, and you can give your house away, or you can sell it, or put a mortgage on it, or do whatever you want. If you're dead, if you're not there, I can't slide the deed across the table anymore. And because I can't slide that deed across the table, you can't sign it. You're the only one that's authorized to sign that deed because you're the name on the deed. That means we got to go get the court's help to transfer that property. That's really all probate is. That's really all we're doing when we're transferring assets through probate, is we're changing title on deeds, changing title on property. So the example here would be if John Smith is the only one that can sign for that deed, sign for that house, what do? We go tell a judge in the county where the house is located, hey, John Smith died, we need you to give us a court order that says somebody else can sign for the deed. That's really all probate is. That's all we're doing. We're just going to a judge, a probate judge, and say, hey, judge, give us a court order so somebody else can sign this deed and we can transfer the house. Okay? So what we do with a trust is, instead of having the assets retitled after death by a probate court, we know that we can retitle assets during our lifetime really easily. So what we do is we retitle the assets before a person dies rather than after they die. And right there is kind of the crux of why a trust helps us, where a will does not a lot of the time. And it's because we take all of our assets, and we might have stock, we might have a house, we might have a bank account, we might have cash, and we're going to take all those assets and transfer them into the name of our trust. So John Smith, instead of that house being owned as John Smith individually, it's going to be owned as the John Smith Trust. Right? Now the John Smith Trust owns the house. Now John Smith still owns the house, still lives there, still sell it, still put a mortgage on it, do all those things you could do before. But In the case that he becomes incapacitated or he passes away, that asset is now in the name of a trust, which means a successor trustee, somebody else, can come in and manage that asset, sell it, give it away, pay the bills, do whatever, without the intervention of a court. We don't need a probate court to help us transfer that into somebody else's name because John already did it during his lifetime. And because it's so simple to transfer assets during lifetime, a trust basically has us transfer all of our assets into the name of the trust while it's still easy and doesn't take very much time, rather than when it gets very expensive and we do a probate after the fact, right? So you can kind of think of the graphic here on the screen is the living trust is kind of like a box. And if you think of a box to protect your assets, when you draft a trust, that's the box. The box is empty. Then we start retitling assets, and every time we retitle an asset, we put that asset into the box. Then we close the box, we lock it, and we put some instructions on top that say, if I die, if I become incapacitated, here's who I want to be in charge, and here's what I want them to be able to do. Okay? So there's three positions to a trust I want you to think about: trustors, trustees, and beneficiaries. The first one is a trustor. Trustor is the person who owns the assets and puts them into a trust. They make up the terms of the trust. They decide who's in charge, what the rules are. That's the trustor. Okay? Trustees, that's the people who manage the assets in a trust. When you're managing an asset, you can buy stuff, sell stuff, trade stuff, exchange stuff. You could put a mortgage on things. You can do all kinds of things with those assets. You're the manager of those assets, right? You manage those assets when they're in the trust. And finally, beneficiaries. This is the fun part. These are the people that get to spend the money and use the assets that are in that trust. This is the part where people, this might be beneficiaries, could be children, could be grandkids. These are the people that get the money at the end, right? That's what we're talking about. Now, during lifetime, right, you can occupy all three positions. So during lifetime, John Smith, if he's our example here, he is the trustor. He set up the trust. He's the trustee. He manages his own assets himself, and he's the beneficiary. And since he's the beneficiary, he gets to spend that money on himself as well. Because he occupies all three positions, it's the gift of total control. And it's really business as usual from a day-to-day standpoint. The trust can usually be amended or revoked at any time. And the trustors can still buy, sell, and refinance assets. You can sell your house, move into a new one. It doesn't change your income tax forms. It doesn't change your property tax bill. All those things stay the same as you go forward. So a lot of people would say, okay, well, why would I do this? Why would I create a living trust? Why would I do something like that? Well, it's a standby device, right? It's a standby device in the case that you become disabled or that you die. We don't want any court involvement, and we want to protect spouse and kids. That's really what we're doing. We don't want to have to go to a probate court for instructions or for the ability to transfer assets to our kids or to our spouse. And so we're trying to avoid that process. Just to give you some idea, probate typically is costing, 3% or so of the assets going through, sometimes a little more, sometimes a little less. That's a good indicator. So if it was $100,000, it's about $3,000 to go through probate. And typical probates on the Kansas side take, 9 to 12 months. And on the Missouri side, they take a little bit longer, more like, probably 10 to 15 months. The statutory waiting period is a little bit different depending on which state you're in. But it takes quite a long time. You can plan on about a year and usually thousands and thousands of dollars to get through a probate process. So people really don't like that, which is why we do a lot of trusts in our office. And so the second document I want to talk about here is a will. Okay, this is the one people associate most often. A will is very simple as far as the definition goes. It is a written set of instructions for what happens to your assets when you die. And this is very important. It's when you die. It's not any other time. It doesn't take effect when you're incapacitated. It doesn't take effect if you're in the hospital. A will has no force or effect in those cases, okay? Only at the time of death. So pros to this, it's simple, it's relatively expensive. You draft it, you forget about it, right? It doesn't do anything until you actually pass away. Now, cons. A will guarantees probate. A lot of people think, and this is a big misconception that we deal with in our office, is that if I have a will, I don't have to go through probate. That could not be further from the truth. A will has no force or effect unless it goes through a probate court. It actually doesn't do anything without a probate judge stamping it and approving it, okay? Which means if you have a will and you want to use it, it guarantees probate. Probate is a Latin word that actually means to prove a will. So yes, if you have a will, you're going through probate. It also doesn't do anything, like I said, in the case of an incapacity. When we talk about death probate, that's that process of changing title on assets that we talked about before. Death probate comes up in many, many cases if you don't have a will at all, or if you have a will, you're going to go through a death probate process. And again, we're going to pay creditors, right? So the judge is going to make sure that creditors get paid during probate, and we're going to do that process of changing title on assets. That's what I talked about before. Where if your name is the one on the deed, the judge has to sign a court order saying, yes, somebody else can sell the house, okay? So that's a trust and a will. Those are the two big documents that are out there. The other four that I want to talk about here are also important, and mostly these take effect in the time of an incapacity, not in the time of a death. So the first one here is a durable power of attorney for financial decisions. Sometimes you'll hear this called a property power of attorney. This allows a trusted person to act in financial situations in the case that you are incapacitated or disabled. Okay, so if you can't make decisions for yourself, you can't sign checks, somebody else can step in and help and do that. Okay, now a couple different things about powers of attorney. One, they can apply without incapacity. What does that mean? Sometimes we'll have them where we have either an immediate power of attorney or a springing power of attorney. An immediate power of attorney means as soon as you put ink on the paper, the person you've said can be the power of attorney can actually start to act. They can go and write checks and sell assets and do all those things immediately, whether or not you are incapacitated. If you have a springing power of attorney, what that means is it springs into action when you become incapacitated. So if you are, you have a stroke and doctors say, yes, this person's incapacitated, only then would the power of attorney take effect. Okay. Now, it may be counterintuitive when you first hear that to say, okay, which one do I want? Maybe I want that springing power of attorney, so it only takes an effect in the case of incapacity. Typically at our office, we do immediate powers of attorney. And the reason we do that is we don't want to have a third party making a decision about whether your family can take care of you. And this makes some sense, right? If we have to do a guardianship or we have to go to a court because you become incapacitated, then we have to get a third party's approval for someone to say, yes, this person can take care of me. That's the same thing we're doing if we've got a springing power of attorney. We don't have to necessarily go to a court, but we've got to go to a doctor or some other third party to sign off and say, yes, this person's incapacitated. If the doctor is hesitant to do that, right? Maybe you seem fine in the morning, but you're not so well in the afternoon, or maybe you just have a little dementia, a little, in and out of bouts of lucidity. We've got some problems there because your family probably does need to take care of you and they know best, but the doctor may not sign off and say, yes, this person's incapacitated where they can't make their own decisions. I don't like having a third party in charge of my family, so I like to have my family members be able to do that. And the common objection we get to that, the common thing is we say, yeah, but if I sign that right now, then my kid could come and steal money from me and go to my bank account right this very minute. And yes, that's absolutely correct. And I will tell you, if you think your kid or somebody else is going to steal from you when you are awake and walking around and can fight back, what do you think they're going to do when you are incapacitated? They're going to be even worse. So, and that's kind of funny and interesting to think about. If you think there's any risk of somebody taking your money, whether they could do it now or when you're incapacitated, don't put the person on the list. Don't make that person a power of attorney, right? You only put people you trust explicitly in this position, okay? Now, the one other thing I want to mention about a power of attorney, which is very important, and this is a big misconception we deal with again, is the power of attorney has no authority after you die. When I say no authority after you die, what I mean by that is if you pass away, the power of authority, the power of attorney is immediately void. A lot of people think, oh, I've got a power of attorney when mom or dad dies. I'll just go to the bank, use my power of attorney, and everything will be fine. Could not be further from the truth. You cannot use a power of attorney after a person passes away. It's ineffective. Next document I want to talk about, healthcare power of attorney. This most people have heard of. This allows a trusted individual to make medical decisions in the case you're disabled or incapacitated. So you're in the hospital, can't make decisions for you. A doctor says we need somebody to sign a consent form for blood transfusion, a surgery, any kind of medical procedure, and they need a signature on a consent form. They're going to come find the healthcare power of attorney. Okay, that's really important. A living will or advance directive. This document sometimes goes hand in hand with a healthcare power of attorney. These are instructions to your loved ones and medical professionals that if you have typically an incurable injury, disease, or illness, and you want to die peacefully and naturally, they will not keep you alive with extraordinary means indefinitely. So if you're on a heart and lung machine, this is their instruction that says, I don't want to be kept alive on just a heart and lung machine if death is imminent, right? Let me die peacefully and naturally, give me some pain medication, and make me comfortable. We want to make sure that when we talk about this with our family, they understand our expectations, and we want to make sure we take religious considerations into account as well. And I mention that only because myself and Chris are both Catholic. Catholic doctrine would state that food and water cannot be removed in a case like this. Other religions, other folks say, if I'm in a terminal condition, I want the feeding tube and the hydration removed as well. That's something you want to make sure your family understands, and you make that distinction with them to let them know what your wishes are if something like this should come up for you. Final document we want to talk about here of the essential six is a HIPAA release. HIPAA is the privacy laws that affects hospitals and medical records these days. This has come full circle or very much into the limelight with the electronic medical records that have come into play in the last 10 or 15 years. This allows family members and close friends to get access to medical information. It doesn't get them to make decisions, but they can talk to doctors, talk to nurses, find out what room you're in, get medical records. Very, very important. If you're not HIPAA authorized, the hospital and doctors are not supposed to talk to you about someone's condition at all, whether they're incapacitated or not. And that can be a real big problem. So we recommend you get a HIPAA release and put all the loved ones you want to be able to talk to doctors and get medical information on that list. Now, specifically with those last three healthcare documents, the healthcare power of attorney, the advance directive, and the HIPAA release, I want you to do one of two things with those. If you are really comfortable with your cell phone and you've got a smartphone and do documents and cloud storage, those kinds of things on that cell phone, I want you to take those documents, healthcare power of attorney, advance directive, and HIPAA release, and I want you to put electronic versions of those on your cell phone so you have them with you all the time. That way, if you get a phone call and you're at work, you're at home, you're out to dinner, and you need to drive immediately to the hospital, you've got the documents with you already. If you are not comfortable with documents on your cell phone, that's okay. We want you to take paper copies of those same three documents, and I want them to go in the glove box of your car. And the reason I want them in the glove box of your car is that our first instinct, typically when we hear that a loved one has gone to the hospital, is we jump in our car and we drive there. And if you jump in your car and you drive to the hospital and you're in an emotional state and you're not thinking about things, and you walk inside and they say, I'm sorry, you're not authorized to make this decision or get information or whatever it might be, all you have to do is walk back out to your car, grab the documents, and walk back inside. It takes 1 minute. If you don't put them in your glove box or have them on your cell phone, you got to go back home, you got to look in the file cabinet, you got to get the book out, find those documents, drive back. We don't have that kind of time. We don't want to take that kind of time. I'd rather them be immediately available to you either in your glove box or on your cell phone. Those are my preferences for where those healthcare documents are. Other tools that we sometimes talk about in estate planning, life insurance, always good to have that. I want to talk about retirement accounts. Those play into our estate plan quite a bit. Beneficiary designations, which we can put on life insurance, retirement accounts, bank accounts, and then if you've got a small business, we always want to talk about business succession planning as well. This one doesn't affect as many families, so I don't go into these four topics in a lot of detail here, but these are other things you might see out there. Most people know about those first three with no trouble. Business succession planning, if you've got a small business, you need to talk to us about that. Certainly send us an email or give us a call, and we can help with that. A little bit of information if we are dealing with a young family. So if you're either in charge of a young family or maybe you've got a young family, you've got young kids at home, and you say, how do I take care of these kids the right way? Three other tools that we use for young families that I want to just mention real quickly: guardianship, life insurance, and a common pot trust. And when I talk about these, guardianship, this is always done through a will. We want a court to approve whomever the guardians are of minor children, and that makes some sense. We've got to have a judge's approval on that. Oftentimes this is different than the person that manages money for your child. These can be family members or friends. A couple of considerations when you're setting up guardians for young children. I want to think about the age of both the kids and the guardians. So a lot of people say, yeah, I've got a 2-year-old and I want my parents to be in charge because they babysit all the time, and my mom is 68 years old. And we say, well, that's a problem. When your kid graduates from high school, your mom's going to be in her 80s. And that may not be the best situation, right? Maybe that's okay for mom to do it right now, but if we're thinking long term, we may want somebody a little bit younger. So we want to think about that. We also want to think about values. Are they going to raise your kids the way that you want them raised, in the manner that you are, going to the schools you want them to go to, or the religious services you want them to go to, those kinds of things. We want to think about values, age, a lot of pieces to think about when we're thinking about guardianship. Those are all conversations that we have in consultations with families, because it's all very specific to each family is a little bit different. Life insurance. When we're talking about life insurance for young families, we usually like to start at kind of the rule of thumb that we usually recommend. It's different for everybody, but usually 10 times annual earnings usually makes some sense. And why do we say that? If you've got young kids at home, we want to make sure that there's enough money there to get them through school, maybe through high school, maybe college, but we want to make sure that there's enough money that we can take care of our family, our spouse, and our kids if we lost the income of the person that passed away. And so that's really important. 10 times annual earnings, that may not get you all the way there. You might need a little bit more. Maybe you need a little bit less if you've got a lot of assets saved already, but 10 times annual earnings is a good place to start, as to kind of say, okay, if we had that much money and it was invested the right way, could we make this work? And that's kind of what we want to look at. We typically talk about term policies for young families. You get the most bang for your buck there, low premiums, high payouts. We want to make sure we manage the beneficiaries the right way. We rarely, if ever, want to put a child as a beneficiary of a life insurance policy directly. We want to put a trust or somebody else in charge of that money for the child rather than giving them a big chunk of change. Minors, we're not giving $1 million to a 2-year-old. That just doesn't make any sense. Okay, so we want to think about those beneficiaries the right way as well. One of the other things we do is we set up common pot trusts for families. A lot of times this treats young kids like a family. So if mom and dad both pass away and 3 kids go to stay with a sister, and that sister has 1 or 2 kids, we want to treat them all like a family. And using a common pot trust, basically that allows us to have all the money for your 3 kids in one single pot rather than 3 separate accounts for each of those kids like we usually do with adult beneficiaries. That significantly reduces the administration for trustees, and it makes it a lot easier to manage that going forward for those children. And we typically recommend doing a common pot. That's something we can talk more about if you come in and you wanted to talk about something like this specifically for a young family. If you see this in the trust that you have been named a trustee of, how that common pot trust works, it's basically just an easier way to administer until the kids become adults, usually 18 or 21 years old. But we can talk more about that. It's going to be specific to each document as to how we set up that common pot trust. Some practical considerations. When would we use these documents? What things do we need to think about? Legacy binder, location list, funeral planning, family meetings, and then meeting with a professional are all practical considerations for literally everyone. Everybody listening to this, whether you have an estate plan or not, these are all really important. And so I want to start with that first one, the legacy binder. If you're a client of our firm, more than likely, you have a legacy binder just like this, and it has everything you need to get going. It's got instructions, informational tools, organizational tools, and all of the legal documents that you're going to need. We want to make sure it's complete. We want to make sure that kids and loved ones know about this. We need to know where the blue binder is, and that it's all filled out. And there's a couple of tabs in there we want to make sure are filled out specifically that I'll talk about here in a second. But that blue binder should be out in the open and easy to find. And the instruction is if something happens, you find the blue binder and you call the number, right? That's going to have all the documents we're talking about. That's going to have who's in charge, what we do, how we do things, all located in there. And the number that they call is our office, and we can certainly help walk through all of these things. We don't charge clients for that phone call. We don't charge for that meeting as well after a loved one passes away. So that's always available to our clients. That legacy binder is kind of like the in case of emergency manual. Make sure you know where that is and it's got all the information in it. Second, location list. Find this list of important documents, right? So you're saying, hey, where's last year's tax return? Where are my bank statements? Those kinds of things. Hint, this is in the binder. There's a tab in there called location lists. Hopefully it's filled out. If it's not filled out as you're looking at it right this minute, take 10 minutes, fill it out right now. You'll know where all this stuff is. It won't take you that long. And basically what that says is, hey, if you need last year's tax return, it's located in the file cabinet on the stairs, right? You know where this stuff is so that relatives and close friends know where things are and who to contact. Another easy way to do this is you can call the office. We have copies of lots of this type of information in our files for most of our clients as well. Okay. Funeral planning. Legacy binder has a good starting place for details on this. We call it the 5-minute funeral planner. It's typically in that front cover of the binder. If you don't have one of those, certainly you can call the office. We can get you one. We want you to think about pre-planning your funeral. Some people like to do nothing. Some people like to pick the handles on their casket. Whichever person you are or wherever you are on that continuum, we certainly encourage you to do as much pre-planning as you are comfortable with. If you would like somebody to help you with that process because you're unsure of the costs or how that works, either before a loved one dies and you're doing pre-planning, or after someone's died and you say, gosh, I've never done this before, how does this work? Funeral Advocates is a great resource here in town. It's run by someone that we know at our firm, and he does a nice job of helping to negotiate funeral rates for clients. Just as a disclaimer here, he doesn't work for us, we don't work for him, he doesn't send us any money, we don't get any kickbacks. We just think it's a good service because we know that funerals can be very expensive, and if you don't know what you're doing, you can certainly pay more than you probably should. And if you use an advocate like this that knows what the costs are supposed to be and knows what you actually need versus what they tell you you need, it tends to be much, much cheaper. And so we recommend having somebody help you. A family meeting. Starting with a presentation like this is a good place to start, but having that conversation is important too, right? It's sometimes a hard conversation to have, a hard conversation to start, but it's one that needs to happen, right? We need educated and prepared family members. We need them to know where the binder is. We need them to know where the documents are. We need them to know who the healthcare powers of attorney are and the financial power of attorney and the trustees. We don't want this stuff to be a secret. And so, checking out this presentation, looking through that binder, making sure you know where things are so that you know when the phone rings, what do? You get the blue binder, you call the number, you get the healthcare documents out of your phone, you get them out of your glove box. You've got the resources and the plan available to say, I know who's in charge, I know where this stuff is, and I know what to do. And that's really what we're talking about. And that's what that family meeting kind of starts. Okay. And then finally, meet with a professional. We always talk about this. This is complicated stuff. I mean, we've been through, 30, 45 minutes of stuff here, and we're just barely scratching the surface on a lot of this. Okay, you need to ask for help when necessary. And so, with that, our office doesn't charge clients for phone calls because we know that their questions will come up, and we want you to come talk to us, and we want to make sure that we can be a sounding board for you and for your family. So if questions come up, how does this work? What do we do? It's available to you, right? You call the number, you get a hold of somebody at the office, and we'll help walk you through whatever you need to do. Hopefully that makes some sense to you. Now, typical fees at our office, if you say, well, mom and dad already have this, or other people already have this, but what if I wanted to do something, or what if somebody else I was talking to said, hey, they want to do something? Some typical fees at our office as of 2018 when this recording is being done. Price is subject to change, of course, but at this time, it's usually $350 to come in for a consultation. It's usually somewhere between $1,000 and $1,500 for a will, depending on if you're single or you're married. The price changes on that. And trusts are typically $28.50 to $39.50. Single versus married price there. Okay. Generally, it's $200 for a real estate deed outside your personal residence. So if we need to move a rental house or a vacation home or something like that into trust, we got to pay some recording fees. It's typically a little bit more of a fee for that. These are all things that we can discuss in a meeting if you wanted to come and see us. If you just give us a call, we can talk about all these things to make sure that your planning is under control. You might not need nearly all the things that we talked about. You might need the whole thing. It really depends. It's a case-by-case basis because no two families look the same and no one size fits all in these kind of planning. We want to make sure we do this exactly right for everybody that's in the office and one of our clients. Another thing about our office is unique. We handle only estate planning matters. So if you have a car wreck or something like that, we're not going to be able to help you with that. We're going to refer that out, and that's okay. We want to do one thing and do it really, really well, so we focus only on estate planning. We only do flat fee billing on this, so none of this is hourly. So if you come in and we tell you the price is $39.50, it's going to be $39.50, and you call once or twice or 10 times, it's still $39.50. Okay? We want you to have some certainty as to what the pricing looks like, because getting surprise bills from lawyers we know is never fun. We review your plan with you about every 3 years. We'll send you something in the mail. We typically have availability to do phone call if there's changes that need to be done. We have a no-charge meeting with the family after death. That is a resource. That is where the rubber hits the road here. This is call the number. You come in, you sit down at the conference table with an attorney that's going to walk through literally everything in that book. Specific to your family, explain what you need to do and how you need to do it. Very, very important that gets done. And then again, I'm reiterating this again, we don't charge for phone calls. That's a little bit different than most lawyers do as well. And we do that because we want to make sure we're on the same side of the table with you. If you have a question about protecting your family, we want to make sure you can call and talk to us about doing that. Okay? So, go back to that question we started with at the beginning. If you got a phone call right now and learn something happened to a loved one, do you know what to do? Yes, I think probably everybody listening right now does. You get the blue book, you call the number, right? You got healthcare documents in your glove box, you got them in your cell phone, you got the blue book, it's got instructions, it's got information, you've got a resource available at the firm. This is the plan that has been put into place for your family, and we hope that you utilize it. We hope that it works really well for you, as we know that it will, and it has for quite literally thousands of families in the Kansas City area. So with that, that's kind of the end of the presentation at this point. And because this is a recording, obviously we're not going to do live questions, but if questions do come up, give us a call or shoot us an email, and we'd be happy to answer those questions for you. Want to make sure this was a good resource for you, and if anything else comes up, please let us know. We are certainly always available for you.